Namaskar. On behalf of the National Center for the Performing Arts in Mumbai, a very, very warm welcome to all the participants. Thank you very much for joining us this afternoon for the third workshop in our series that has been specially curated for performing artists, especially in the wake of the situation that has arisen under the circumstances, the pandemic that is raging all over and the circumstances arising from that. At the outset, we would like to express our sincere gratitude to HSBC for their support. We truly value their support, continued support to our skill building workshops and other initiatives. If you will see the themes that we have been dealing with in the current workshops, you will see that all the themes are outside the domain of performing arts. But nevertheless, we believe that they have in some way indirect connection bearing on the professional careers of the performing artists and other components in the ecosystem of performing system. So that is why we have chosen this. We started in the month of September. The very first workshop was understanding the digital space itself, because that is something new to the performing artist. In October, on the World Mental Health Day, we followed it up with how to understand your psychological stress and, more importantly, how to manage it. And that also was a second workshop. And today we shall be talking about some legal issues, again, especially in the light of the pandemic situation and the very deeper impact that it has had on our lives. The way we have embraced the digital technology, we need to relook at all the legal issues, etc. We know that the technology it's by itself is not a new thing to us, but the way we have all embraced it seems to be really unprecedented in the history of humankind, maybe. Coming to the performing arts and artists, we know that the way we are creating today the work, the producing the work, it is being taken, transmitted, conveyed to the audiences, and the way the audiences are consuming this are all have taken a paradigm shift from what we used to do when we were in the physical spaces of our venue in the theaters. So it becomes imperative, and as a result, what has happened, unfortunately, that the copyright laws, it seems, have not kept pace with these kind of technological advancements, and therefore some gray areas emerge, some contentious issues can emerge, which the artist needs to be aware of. And today, to deal with all these issues, we are privileged to have with us Mr. Sanjay Kher, a very senior practicing lawyer of the Mumbai High Court. He also specializes in intellectual property laws. He has vast experience, international experience of handling contentious patent and copyright litigations and prosecutions. So friends, we are in a very good hands. And thank you, Mr. K, for accepting our invitation. We know how busy you are, and really super busy you are. And thank you so much for accepting our invitation and agreeing to help our artist friends with this kind of issues. And we look forward, Mr. Care, to understand basically the copyright in general, and also in the wake of today's digital domain, how to look at it, what are the ethical and legal issues arising, etc., etc. So before I hand over the microphone or the proceedings to Mr. Kher, may I once again thank all the participants. I will also request you to post your comments, queries, etc. in the chat box so that Mr. Kher at an appropriate time can address to those issues. Also sharing with you that the past two recordings of the past two workshops are on our NCPA Facebook. So should you want to refer to that, you are free. They are all available free. So friends, there you are. Thank you again very much, all of you and Mr. Kher, and over to you, Mr. Kher.
Thank you, Mrs. Rao. Thank you, NCPA. Thank you, HSBC. Thank you, Mrs. Rao's dedicated team of Bhakti and Dhanya, who have guided me through the technological labyrinth to reach here. Now, let me begin with a little disclaimer and probably also an apology I owe you all, because exploring the various labyrinths, as it were, of the digital domain, and to do it in the time before us is going to be next to impossible, because various issues like privacy issues, web archiving issues specifically relating to museums, libraries, and a plethora of subtopics can come up for discussion, and I may not have the time to get into all that. So I've kind of restricted myself to discussing with you the issues relating to digital content and its management, and its management and its rights of users, and the problems arising out of that, digital rights management issues. So I want to be in that space with you today in the time that I have with you. Understanding that I'm not going to be covering directly a lot of things, I'm absolutely open to a lot of questions. In fact, I've already received on my email many questions, and I understood from that the interest is far wider than the time that permits me. So what I'm going to do is I've done a slight shift in the format of the program. What I thought I'll do is, rather than speak a lot myself, I'll lay down the general principles that I think we all need to be sensitized about, and then straight get into question answers and try to cover the topic not just on what I convey to you today, but also on some other things that the participants may want to ask me on, and through that maybe we can keep extending our circle of understanding. So if that's okay with all of you, let me begin. I'm also told by Mrs. Rao that we may have a cross section of an audience today, and therefore I must try and find that sweet spot between the experts who are over here and probably the novices in the law who may be here. So I'm going to be attempting to do that, and probably that's also why I thought I'll do a little rejig of the way otherwise I would have wanted to talk to you about. Okay, so let's do one thing. I'm going to put before you a small poll of 5 questions. The reason why I want to do that is that the result will tell me the audience profile we are all faced with today, and that would then allow me to tailor my conversation with you as we go along. So may I request Dhanya to kindly put up the poll, and friends, what I suggest is a short yes and no question, just to give me a feedback. So you may just rush through it quickly, and we can then proceed with our program today. Okay, so the results are mixed, and it gives me a sense of the audience profile. And what I need to do is I need to take a large number of the audience through some of the basics of the copyright law, because unless that foundation is clear and well settled, any understanding of what happens in the digital domain would be impossible, because the subaltern law is the copyright law, and that is the law that survives. And so I'm going to take you through the copyright law, and I'm probably going to have to share my screen with you. Being an IPR lawyer, I also need to tell you very briefly. I'm not staying here longer. As to for all content creators, really, issues before lawyers today are not just limited to copyright law. Organizations are taking a ring-fence view of intellectual property. What that means is that on a particular subject matter, the content owner, it could be a corporate, it could be individuals, whoever, now desire to create a ring fence of various intellectual properties to be able to better protect what has been created. So this is called the ring fence of intellectual property. This is just an example. Just read it. We will proceed it. Hopefully, we'll get another day to talk about this. So what you see here is that the 4 or 5 leading intellectual property laws have been mentioned, and you would see how in a single Kodak camera product, each one of these laws can be brought into play by the organization, creating a ring fence of intellectual property around that product. I'm moving ahead with this. Now, let me tell you very, very briefly, and please note that these are very, very broad statements that I'm making. Each one of them are capable of substantive discussion at some point. But for today's purpose, very briefly, what would intellectual property be all about? And as most of us understand it, it is something created by the human mind in which the law has come to recognize a set of rights, and that's enough for today. And some more features of that you may want to just appreciate is that it's a primary feature of this property rights or subject matter here is that it is an intangible. 2, the laws governing each of these each of the intellectual properties really are territorial in nature, and at the same time, while there is a territoriality aspect to that, at the same time, India is a signatory to a plethora of conventions and treaties, including the international the Copyright Order 1999. So all these makes, to an extent, the concept of territoriality to be looked at a little differently. But having said that, these laws are crafted, the statutes are crafted for the territory called India, and as will be defined in the Act. Some of the intellectual properties also roam about in the area of common law provisions, but not our copyright. Our copyright, we have the copyright book before us, so we will be looking at the copyright book. Now, what do we understand when we use the word copyrights? Very simply for the layman, copyright means the right of the owner to make copies of his work. I'm using the word to make copies very generally because you will find what an owner can do with his work more expansively stated in section 14, and I've got a slide to show you what is the coverage of section 14. But suffice for us to understand today broadly, and since I guess many of us are not lawyers, is that copyright is the right of the owner to make copies for the moment. Mind you, I have used the word owner. I have not used the word creator or author. Author is the word the statute uses. I'm using the word author and owner. So the rights are enshrined in the owner and not in the author. It is a different matter altogether that you may have a situation where the owner and the author may be one person, and in which case we have a different section that deals with who is the first owner of the copyright, etc., etc. That's section 17 of the Copyright Act, and we'll come to that a little later if required. What does copyright do really is it grants you a bundle of rights. We also call copyrights as a bouquet of rights. Now, what's amazing about this bouquet is that each of the flowers in this bouquet can be dealt with separately by the owner of the rights. For example, if I were to write a book, I could give the language Marathi translation to one person, the English translation to another person, and so on and so forth. I could give the Marathi translation in paperback to one person, and etc. I could give the film rights to a person and the theater rights to somebody else. Some other rights I could make, the rights to convert it into a comic book, whatever. All these various things that I can do with my creation or the creation which I own, I may not have created it, these all go to form the bouquet of rights. And I can deal with each of these bouquets separately. And that is what makes this law a very interesting and amazing law. And of course, suffice to say that it's a form of property in the sense that it's a set of rights have come to be recognized in these creations. So that's the first door we have entered through. Now let's enter some other concepts. And since this is not a lecture typically on copyrights, I'm just going to skim over some of the ideas here, because some of these may form a part of your questions or something that I see later on. Now, some fundamental principles are that there are no copyrights in ideas or themes or principles. Copyrights resides in ideas as expressed. So expression is a very important feature of the copyright law. So you just can't have a thought in your mind, a creative thought in your mind and say, oh, now that is it in my mind, it immediately lends itself to legal support. Answer would be no. It ought to be expressed. And once it is expressed, it can be open to various kinds of discussions, how much it is expressed, in what depth has it been fleshed out, and various other discussions your lawyers will always take you through if you want to sue somebody on that. But suffice for today to understand that copyrights have to be, for you to get a copyright in a subject matter, that subject matter needs that idea, that thought must be expressed. Does it need to have an artistic quality? Answer is absolutely no. All it needs to have something called as an originality. Mind that word, underline that word. Originality is an abiding principle in copyright law, and it takes us to many places. And one quick place I may mention to you is that two people can create an identical work, similar work, and yet if the work has been created independently by them, both will come to enjoy copyright in that. It's a very unique feature of the copyright law. This feature you may not find very easily in the patent law or even in the trademarks law, where actually it's the first one, is the first past the post system there. So if you've done an inventive work, if you are the first one to file it, even if I am the first one to invent it, I may probably lose out in India. And similar goes to the trademark law. I mean, if you are the first one to adopt a trademark and use that trademark, you would have better rights than the person standing second. In this case, in the case of copyrights, two people can create identical works and both would be recognized as owners, or at least authors and owners of the work, provided both of them can establish that the work has been independently created. How that can be established is the subject matter of some other discussion on some other day. So with these principles, let me take you straight to section 13 of the copyright law, which tells you what are the subject matters in which copyright exists. The subject matter for copyrights are largely, let's take the first four that I mentioned there: literary work, dramatic work, musical work, and artistic work. These four are the pillars of the subject matter on which copyrights exist. Two other subject matters are mentioned there: cinematograph, films, and sound recordings. But we may leave that to some other day, simply because they incorporate all the four in one form or the other, and the four mentioned above transform themselves to find some identity in a sound recording or in a film, and that's a subject matter again of a long discussion someday. So mind the section 13 that I've placed before you for your consideration. And now I come to section 14. I'm sorry, I've not mentioned section 14 there. Now, section 14 is what is really the meaning of copyrights. Earlier, I just said to you, it's the right of a person it's a person's right to make copy, the owner's right to make copy, but the owner also has a whole lot of rights. And if you quickly peruse this whole lot of rights that a creator, that an owner has, you will see that almost anything and everything that can be done with a creative work is in the domain of the owner of the work. So if I may just read it out to you, it's to reproduce the work in any material form, storing the work in any medium, issuing copies of the work, performing the work, communicating the word, to make films, translations, adaptations, and including these rights are being made applicable to translations of the words or changing of form of these words. So you would notice that the ambit of section 14 is really very wide. It's important to note this because we will be dealing with this when we understand whether the definition changes, the understanding changes when we go to digital works. Okay, so please appreciate that the owner of the work has almost all the rights that he can in relation to his work. Okay. Now this is just to cull for you what are the various things that artistic work, literary work, dramatic work, and musical works really all include, and it will take you to a whole lot of areas of human activity. So you'll probably notice that almost everything that human beings do, almost everything, may be able to be covered in the four subject matters you saw under section 13. And so again, emphasizing the importance of the copyright law. It's a very short law, vis-a-vis the patent law or the trademark law. But it's a very dynamic law. It's got wonderful complexities for the experts to get into. It's personally a favorite law of mine. Okay. Now, how is copyright created? I said that to you a little earlier, that the subject matter of the copyright of what you are seeking copyright in, that has to be expressed. Now, again, I'm not getting into too many details today here because once, as I said to you earlier, once something is expressed, that expression itself is subject to a lot of debate in the law as to how much is and what is the quality of expression, how much has been, as I said, fleshed out, and what are the detailing, and what is sought to be conveyed, what is being communicated. So lots of debates can happen on the concept of fixation and securing copyrights in that. Then the question, is copyright registration necessary? Okay, so the answer to this question is no. Registration of a work is not mandatory in order to claim copyrights. So what does it mean? It means that the sheer factum of the work having been created by its author is sufficient for the work to secure the protection of the copyright law. I know from experience, many of you would be confused as to then, if that be the position, how would one be able to establish that I am the one who created the work? The answer really doesn't lie there. The answer really is that if I can prove it, that I am the one who created it, then would I have the rights as its author and owner? The answer would be yes. And that's all that is required by the law to protect and bring into play the features of the copyright law. So registration is not mandatory in order to claim copyright, which is the answer to the first poll. Now, copyright notice. It's a small, cute point. I thought I'll just mention it for you. Many of people are confused as to whether we should mark our work along with a C in a circle. And if I don't do that, would I be losing my rights, etc. So the short answer to that question is, acknowledging the fact that you are the copyright owner of a work is not required by law. It doesn't reduce the strength of your claim. It doesn't deny you the claim. If at all, it may help you. If you do it, at all, it may help you to pin the defendant a little more tighter, because then what you're telling the courts is that I had even mentioned that I am the copyright owner of it, and despite this infringer has done his deeds, and therefore, to that extent, if not the courts in our country, but at least in many other countries, you may find the quantum of damages being awarded to you might move upwards. So that's an advantage of mentioning or claiming copyrights by a symbol the universally acknowledged symbol. But otherwise, not mentioning it, as I said, doesn't make a difference. Now, quickly, we are going to see some of the concepts. Now, copyright has a term. Unlike some other intellectual properties like trademarks, we generally do not have a term. If they are continuously renewed, they can be used as long as they would have rights as long as they are being used. But copyrights, like patents, has a term. Now, patents, you're all aware of that the term is 20 years from the time of its filing for a patent. Now, there are no patents unless you have filed for it and been granted a patent. So your protection is for 20 years from the date of filing the patent. Now, the reason I mentioned that to you because copyright doesn't require to be filed. Then from where would be how would you limit the term of the copyright? The answer is very simple. The law says it will be the life of the creator. Mind you, life of the creator, not life of the owner, but life of the creator plus in India 60 years. Now, why 60 years? Well, there is at least there is some benchmark we have to achieve under the TRIPS agreement, so which mentions 50 years. So we could have been very happy with 50, but I'm told that there was. I mean, I stand subject to be. I stand to be corrected. But at around the time the TRIPS agreement was being put into motion, it was felt by our bureaucrats and our politicians that there was some works relating to Subhash Chandra ji, and therefore which were coming for expiry. And if it had been 50 years, it would have expired immediately. So I'm told that there were considerations, different considerations, but nevertheless, it's always good for all the authors and all the owners really to have their copyright term as long as possible. Of course, it does affect people's right and access to work, and we will discuss that a little later. Geographical limitations, yes, but let's move on. Permitted use, okay, let's move on because I'm looking at the clock and and I have a long journey ahead of me. Now the concept of fair use. Now you saw that copyrights means the right of the owner to do certain things. Now, can I pause here for a minute? And can I take you? I've done section 13 with you, section 14 with you. Let me quickly touch upon section 17 because they form the Trishul of the Copyright Act. Now, what section 17 does really is it tells you who is the first owner of the work. Okay, so logically, if I'm sitting in my studio making a painting, I am the first creator I am the author of the work, and I'm also its first owner. Now, what would happen if that work is a commissioned work? What would happen if I'm a journalist working in a newspaper, writing an op-ed for my paper as a part of my employment contract? So the law has something to say on that, and the law says that in such situations, the authorship will remain with the person who has created it, but the ownership will transfer at the time of creation itself to the newspaper, or in the matter of a commissioned work, to the person who commissioned the work. So mind you, so now what has happened is there are two sets of rights have been created. One is the right of a author who earlier could have been the owner himself, but now he has been divested of his ownership at the beginning itself, and an owner has come to be. And as we all know, property rights, or the set of rights which law recognizes, are always in the owner of the work, irrespective of who the author or the creator would be. The author we now require for our purpose, very interestingly in the copyright law, except for a few places where required, the word author hardly finds mention. It will find mention in the definitions. It will find mention in section 17. It will find mention in the term of the contract. And it also finds when you discuss the moral rights of an author. There are a few places where the term author appears, but largely the author starts having lesser importance for us. And it's the person in the alpha male in the room is now the owner of the work, because it is in him the rights have all come to now vest. Okay, now having done section 17, let me quickly come to fair use. Fair use is an exception to the copyrights, because section 14 tells us all that the owner of the work can do. Section 52 of the copyright tells us what all of us can do without having either a license or a permission or an assignment or whatever, without having anything to do with the owner, what I can do, and the law would recognize it as my fair use of my work. So fair use is another very, very important concept which we are going to see when we talk about digital works, because that's an area where most alleged infringers want to park themselves and find safety and find a safe harbor in the concept of fair use. Compulsory licenses, we can do them some other day. It just means that under certain stated conditions, the public at large can apply to the authorities demanding a compulsory license to exploit a work. But let's leave that. We have a lot of other things to do. Okay, I'm going to move here. There are also two quick rights I want to mention to you. You may find this, one of them is important for us today. These are the rights of broadcasting organizations and the rights of performers. These do not find themselves, you do not find these along with your under section 13. These are mentioned separately under the law. They appear in chapter 8, section 37 to 39 of the Copyright Act, where you have rights relating to broadcasters and performers. What it basically means is that a performer, for example, me today, I am a performer before you today all. And therefore, do I have any rights? Does Lata Mangeshkar have any rights? Because she's neither an author of the work, neither a lyricist, and neither the lyricist, neither the composer. What is she doing? Where does she fit into all this? Where do I fit in? Because I'm speaking to you today. Should any rights come in me? The Act says yes, and I could be classified as a performer. And therefore, before making a sound recording and a video recording of what I'm talking to you today, the NCPA has been careful enough to take my permission before pressing the recording button over here. So that's what is about a performer. You have to take performers' rights. Similarly, broadcasting organizations, because they have digital content, and that digital content doesn't belong to everybody. I mean, you can't just download some material and say and broadcast it separate, or you can't take a feeder line from somebody's broadcast and feed it to your own set of people. There are a lot of things that you can't do if with somebody's broadcasting rights. And broadcasting rights are also beautifully exploited. There are huge amounts of money invested in them, particularly when it comes to sports, cricket, or the very sustenance of all media houses. So these are another two areas that we need to remember. These entities also exist: broadcasting organizations and performers. And very briefly, you may find here the term of copyrights mentioned for various people or various subject matters, really. So as I said, literary work, dramatic works, musical works, artistic works, it's life of the author. Plus 60. These are not concepts apart. This is not really directly important to us today. And as I said, this is something you need to see. Now, a piece of work, but let's particularly take an audio-visual content, or let's take, for example, a simple song for that matter. A song has multiple components in that. So you have firstly an idea for a song. So somebody, the producers, the directors, they thought of a song to be inserted in a film or whatever. Now that idea for a song does not have any copyrights whatsoever, as we already discussed that earlier. And then you have the lyricist. Does the lyricist have any rights? Answer is yes. He has a literary right in his work. What about the composer? The composer has musical rights in his works. What about the singers? Well, we saw that they have a performer's right in the work. And what about the producer who brings all of them together and creates a sound recording? You saw under section 13, the cinematograph, film, and sound recordings. Here is that sound recording that the producer has made. And that sound recording could also come in a non-filmy atmosphere. But I'm just taking a film example for that. So there are multi-party rights in creativity. Why this thought is very important for you? Because I've been asked questions as I have got permission, and yet I have been claimed by a platform for copyright infringement. The answer is because you took permission, but you took permission only from one of the persons involved. You didn't take permission from the other people involved in the party. So that's why it's important to understand multi-party rights in creativity. And of course, there are civil and criminal liabilities for infringement of copyrights. With the introduction of section 65A and B, additional elements have been inserted in terms of liability, because it's also you also invite criminal liability, criminal action if you try to bypass any DRM systems, the digital right management systems, or the RMIs that have been installed by any organization. So to bypass them is also now an offense. If my memory serves me right, the punishment is 2 years for that. So there are civil and criminal liabilities for infringement of copyright, something which everybody must note. Now, our today's discussion, we are in short, and I'm just trying to précis the whole discussion. We are faced with two opposing forces. On one side, we have the content creators, and the other, we have the content users. Both of them claim rights under the law. And this law could be, I'm not taking you into the TRIPS agreement, the Berne Convention. I'm not taking you into the WCT, the WIPO's PPT. I'm not taking you through the European directives or the American DCMA. So let's leave the detailing apart for some other day. But almost all the laws of the world essentially deal with these two entities, the creators and the users, and the constant battle that law has to do to find a balance between these opposing forces. Okay, so please appreciate that. And when we talk of copyrights, and when we talk of copyrights and the digital media, let me tell you a couple of principles that are important for us to understand. That the basic principles haven't shifted. The basic principles of the law haven't shifted. The content owners are perennially on the back foot when it comes to dealing with technology, because they fear that technology creates or takes away or creates new avenues for loss of their control over their work. On the other side, content users the profile of content users have also changed, and we'll come to that. Once upon a time, content users were only content receivers, and they had very little play in terms of uploading their own content, which everything has changed particularly after platforms like YouTube and so many others introduced newer ways of dealing with content and enabling individuals to deal with content. But let me assure you that there's nothing to fear. The legal principles are the same and unchanged. What has changed is the logistic arrangements, or how to arrange the new furniture in the room. That's all. Nothing has principally changed in the copyright law. In fact, there's a very well-known 2019 UTV software case in which UTV was asked to answer the question. The question placed before the law was that whether an infringer of copyright on the internet is to be treated differently from an infringer in the physical world. That was largely inter alia many other questions that the court had to answer, but inter alia this was one of the questions there. And the court answered it in the negatives, and held that there is no reason why in the physical world what is a crime ought not to be a crime in the digital world, especially when the copyright law does not make that distinction. So this is what I was telling you about. In this is a case in which UTV Software Communications had filed a suit alleging infringement against 30 websites, including some of them were John Doe websites. And many of you would know what are John Doe websites. So these are John Doe websites against the Ministry of Electronics and Information Technology, Department of Telecom, etc., etc. And that is where I thought I must share this thought with you, that the courts held that whether it's in the digital world or in the real world, a crime is a crime. Infringement of copyright is an infringement of copyright. Now, very interestingly, the reason why we are actually meeting here today is that the system, when I use the word system, let me correct myself quickly. What I mean by the system is the law. The law still thinks analog. That is a problem. And when you talk law, it also means the people who run the law. We still think analog. Whilst the rise of the household PCs, the digital technology, internet, the file sharing tools, all these have made distribution of digital media so very easy, and which is what scares content creators, because when the protected media subject matter is moved, the owner's rights are compromised. Thus, what I always say, that a legal upgrade is necessary. Legal upgrade is necessary, and for example, I asked you a question as to the sharing of book. Now, some very interesting things happen. If in the physical world I were to share a copy of my book to you, it would just mean that I would lose a possession of my book and limit and access to that book for a while, and you would have that book for you to enjoy and read the book. Now, something else happens in the digital world. In the digital world, sharing a book with you means creating a copy of that book. And the moment you create a copy, you are looking at section 14, which says it's the right of the owner to make copies. So therefore, much of the confusion arises because we think analog, whether the world has gone digital, or at least much of the world has gone digital. Okay, now let me see anything here. So I don't need to take you through all this. If most of you know that the characteristic of the digital technology is its ease of production, ease of dissemination, and ease of storage. And here I come to two very, very fascinating cases. And already, if I look at my watch, I know I'm running against time again. Bhakti and Dhanya, please caution me when I need to tone down, because I have so much material to share that I can go on and on. Okay, now I need to quickly share with you two very interesting cases, and one is of course the Sony versus Universal Studio, which is the famous 1984 Betamax case, where essentially Sony, which developed the Betamax videotape recording format, was sued by Universal Studio and Walt Disney as a contributory infringer. Please note that word, because you're going to come across that often in the digital world. A contributory infringer. And while they did not sue the homeowners who were actually using pirated material, they sued because obviously they felt it unwise in the marketing from the marketing perspective to sue homeowners. But they went after Sony for its Betamax videotape recording format. The Supreme Court, while there were some early victories, eventually the US Supreme Court held that the sale of a copying equipment is like the sale of any other article of commerce and does not constitute contributory infringement. And because the key words being, if the product is widely used for legitimate, unobjectionable purposes. So Sony was through. The Betamax technology was through. It, of course, Betamax didn't survive much. Other technologies overtook Betamax, the Betamax format. But what this did establish was the principle that you cannot shoot the messenger. The messenger will be allowed to thrive, and that was a landmark judgment, because thousands and thousands of technologies and platforms thereafter proliferated under the umbrella of the Betamax case, without the fear of being hauled up as contributory infringers. Now, matters came to a head somewhere around 99 or 2000, I forget which year really, but the Supreme Court eventually, US Supreme Court gave a judgment in 2005 in what is known as the MGM versus Broxter case. Now, in this case, a lot of other people also joined in. Napster joined in, and so many other people joined into this battle. And in this case, very interestingly, the Supreme Court did hold Broxter as a contributory infringer. Now, is this different from Sony? Answer is still no. This judgment doesn't seek to unseat Sony. Sony still survives. But what it does is it establishes the importance for the platform to be largely used for infringing purposes. And that's what Broxter, Napster were doing. While the P2P sharing was happening, it was largely these formats, these platforms were being used to share copyright protected material, and which is why these organizations were held to be contributory infringers. Now, these are two absolutely landmark cases. And of course, after that, many important cases have developed, and we will deal with them again on some other day. But suffice to say that the reason why you see YouTube and so many other platforms taking so much of care, in a way self-regulation, is to come out of the umbrella of contributory infringer, and they are offering all. I've argued in the past that their platforms are also used for non-infringing works, but that part or aspect of the infringement of copyright that happens using the YouTube platform. It could be YouTube, it could be TikTok, it could be anything. The law, in fact, TikTok is very interesting. What TikTok has done is TikTok has tied up with music, with content providers, and have taken a license, a universal license they have taken. Therefore, if I were to take a number and perform make a small YouTube clip, that would not bring me under the copyright infringement, because permissions have already been taken. So that's a different debate. So where were we? Okay, so yeah, we were at MGM and Broxter. So we saw these two seminal cases, and participants might be called upon to read these cases. They're very, very interesting debates, and it's quite a pleasure to read them. Now, while we go through the legal issues in the digital domain, with platforms, and the reason why all these issues started coming up is because of the advent of platforms such as YouTube, an individual also became a content creator. And why not? Why just that? It's a whole lot of digital social media, including WhatsApp, which enables you to just pick up data from one place to the other, send them as attachments, send photographs, files, all this whole lot of thing that happens on social media. All this has made people as the content creator, and that is, so there's one issue. Somebody's sharing something which is copyright protected is one issue. A major issue that we might be concerned about is people who create content want to use the content already available. It could be that I'm making a video of my son having a bath, for example, and singing some lullaby or sing some, and I just happen to put that video on social media. And suddenly that lullaby makes me liable for copyright infringement because I haven't taken permission. Of course, my defense would be fair use, but that's a different discussion whether I would succeed or not. But the long arm of the copyright law does start getting extended towards me. So there's also another angle before I forget. That these independent video broadcasting or this content broadcasting also has a substantial revenue stream attached to that, and that's what also complicates, because that's what hurts. That's what the content creator says. That but this can let me tell you, this can go to ridiculous levels. And but before I take you just to one or two quick examples, let me say this: that while we talk about content creators, content users, and fair use and all that, let us appreciate one principle. The principle is that when a content owner places his work in the public domain, unless specifically stated, it is not for yours to take. And if you keep this principle in mind, you should be safe most often. So please understand, me sharing some material is not equal to a license to you to use, and which is what actually most of us believe it is. But it is not your license to use. That you don't get prosecuted is a different aspect altogether. But principally, the content shared with you is only for your reading pleasure or listening pleasure or viewing pleasure. It is not for yours to copy. That is the principle we lawyers work on. But not, let me tell you how, as I said to you earlier, when I said to you about at what ridiculous levels this can go to. You all know of Prince, right? So his famous song "Let's Go Crazy." Now, a 30-second clip of a mother recording her young son dancing to "Let's Go Crazy," where the music is even barely audible, had to be removed. Now, the clip did not attempt to profit from Prince's work. It did not depend on his song. The baby might as well have been dancing to anything else in the world. But it shows how ordinary folks fall foul of the copyright law. But of course, I must also tell you that this case had a happy ending, because when the fair use law was applied, the clip went back on. Because let's please note one thing, that the system works on the presumption of guilt. And that's how all the platform policies also. There's a presumption of guilt. In some form or the other, they try to be fair, and some sites are more fair than others. There's another case where you have heard of the YouTuber Mr. Beast, whose channel made a clip of 100 million Orbeez, and he and his friends humming in the background Bon Jovi's famous number, "Live It on a Prayer." Now, Mr. Beast's channel had 62 million viewers and had a substantial revenue stream. But he got sued by Bon Jovi's lawyers, saying that your use of "Live It on a Prayer" is an infringement, and therefore the revenues that you've got from this video should accrue to us. Now, you are already noticing how kind of complexities, whether the song itself was the result for the revenue, whether any other song in its place would have still been the same revenue, whether had the song had been muted, would the revenue have been affected. So all these battles will go on in the courts, and not on the platform, but on the courts really. So these ridiculous situations. Somebody wants to teach guitar. Somebody wants to teach some musical instrument. There are clips of classical vocalists in India helping people to learn singing. And some of the songs, they take a Hindi film song and they take them to teach you. Now, would that amount to infringement of copyright? Well, people have been sued for this. And probably most often they've got out of it, but you can't get away from it. So now these are the legal issues, therefore, that arise in the digital domain. If you have read them, I'll go to this thing. Now, very quickly, let me take you to what is the determinant of fair use. Fair use is not determined by YouTube or by any other platform. Fair use is to be determined by a judge. Please note that it's always to be decided by a judge and not by a platform. What a platform does is it merely does some self-regulation. Now, what is fair use? If you take somebody's work, for you to be out of the fair use concept, please note that your use of that work must be, and the key word used all over the world is transformative. The taken work has to transform itself to such an extent and in such manner that the courts are led to believe that there is an effort to add and not an effort to mere copy. What other aspects will determine fair use? It will be monetizing of the concept. It will be monetizing of the whether you are monetizing the YouTube the content, whether a large amount has been borrowed. Please mind, I did say earlier the amount doesn't matter, because I've asked you a question. Taking less than 5 seconds of an audiovisual work would not amount to infringement of copyright. The answer is no, it would amount to infringement of copyright. It would amount to. Because nowhere does the law, it's a great myth that is prevailing amongst even some lawyers, I may be sad to say, that oh, taking 5 seconds is all right, taking 30 seconds is all right. Answer is no. No amount of seconds are all right if you're infringing of copyrights. If there are any seniors like me on the group, taking the tune of Bridge on the River Kwai, the famous musical note, for just 2 seconds cost the producer very dearly. So don't get into timing. Now, so essentially, the courts look at a whole lot of things. Like I said, small amounts don't matter. It also doesn't matter whether you're monetizing or not. You could be very well not monetizing, but the courts could still come to a conclusion that you are infringing. It also doesn't matter whether I've given credit, whether I've said, no, if I'm infringing somebody's work, I'm sorry for it. None of that matters. If you've taken somebody's work, that's the end of the story. You've taken it and you have used it. You are liable for infringement. It's a different matter that companies don't go after everybody. They just seek to monetize it. They seek you to take it down. That's a different matter altogether. What's really important for you to note is that you can be sued. Okay, now, yeah. So let me quickly run this. What is the checklist to avoid litigation or takedowns? So please note, as I said, only courts can determine fair use, not content ID. Most of you would know content ID is a facility offered by YouTube to be able to screen and identify copyright infringing works. So also platforms cannot arbitrate on fair use disputes. Never assume fair use. Always get it checked with your lawyers. Always err on the side of caution. Firstly, don't use copyright protected work. Use tools to identify the content that has been claimed. Don't also take, because there are many false websites going, false entities going on the net who will send you a notice saying that, oh, you've infringed my work and please deposit so much of money. So please identify, please be careful, please check, use the tools that are available. You may also want to use public domain or safe tracks. YouTube provides many other platforms provide it. Whether they are good or bad is a different issue, but these are safe tracks to use. They are free of copyright. Always add timestamps to the claimed portions. You know, when a claim is put upon you for copyright infringement, it helps to make a timestamp on that. And that's a facility YouTube offers actually. The reason is a lot of subsequent legality can be handled by stamping, and it helps you to continue monetizing it, helps you to get out of the thing, so etc. And of course, remove this thing. So if you are taking licenses, I'm hurrying through them because I'm running out of time. Please excuse me for that. Okay, now licenses the digital domain. Always use copyright-free content, safe material. But if you're taking a license, check the limitations on its use. You know, you may have, like I've written below, you may have a durational limitation, you may have a geographical limitation. Look at the payment terms and always seek legal advice. Now, DRM tools are now recognized by statute. So your digital rights management, and information RMI tools, all these tools are very important because these enable, for example, even blockchain is being used for rights management. So what they really try to do is to prevent unauthorized use of digital media. But the fault line here in the use of DRMs, and this is a subject matter of a huge debate all over the world. Use of DRMs and RMIs actually come in the way or restrict the ability of a user to make fair use, to take and use, make and qualify that as fair use. Because a lot of time the access to content itself is prohibited, and that makes it difficult for me to use the work and yet say, for example, I'm a teacher, right? If a company is going to keep certain material inaccessible to me, how am I going to be able to access it? I can't download it. I can't do anything with it. I cannot print it. I cannot share it. I cannot edit it. I cannot create screenshots. Now, how am I supposed to then take that material and teach my students about that? So it also restricts the rights of fair users. So this is about DRMs. And that's about all. I think, Danya, uh, I would like to. You want me to move to Q&As, Danya?
Yes, Mr. Kher, we can do that. I'll just drop in the questions to you.
Yes, yes. And friends, if I'm unable to answer, because I've got just 15 minutes to answer your questions, in case I'm unable to answer all your questions, rest assured that I will answer them, and either me or on my behalf, somebody will answer your questions, and we will get those questions across to you through through Dhanya and her team. Dhanya, that would be possible, right?
Yes, yes, that would be possible. We'll also be broadcasting this on Facebook. So if there are any questions or comments, they can add it there and then we can respond later.
Okay.
Mr. Kher, you can see these questions?
I can see, yeah, I can see some. I've got some on my email. Okay. How does Saregama claim copyright over songs which were created in the 1950s or even before? Broadly speaking, most of the sound recordings are owned by a company or a record label. While these are not natural persons, how do we understand when the term of the copyright vested in these companies gets over? Yes, good question, Kalyani. Your question relates to sound recordings, and therefore sound recordings have a separate life in themselves, as you would have seen in my slide, and that is from the date of its first publication. Now, I may be handicapped to answer a very specific question. Why does Saregama claim? Well, a little light-hearted answer to that is let them claim. It doesn't mean they are right. So, many a time people have got away by just making the claim and nobody examining the veracity of that claim. And I have had experiences dealing with some of these music companies where, let me share another example I had with you. What is true for companies also true for individuals. Chitra Singh ji, Jagjit Singh's wife, was telling me that Jagjit ji owns all the copyrights of all the ghazals that he has sung. And I was a little surprised. So I said, ma'am, can I see the documents? She said, no, what documents? Jagjit, they came, met Jagjit ji. Jagjit says, ye sab, so now can I use it? Ye main kar lu isko? And since then, they have stopped using it, and Jagjit ji has been using it. So they all belong to Jagjit Singh. And we were so frightened because the project to publish Jagjit Singh's ghazals was a mammoth project. And that was about to be released. We said, boys, we just relied on, they came to me a little later. So you said, we just relied on Chitra Singh ji's oral confirmation. Where is the written confirmation? And nobody had it. And then we started inquiring into who are the owners, and we went, and there were hundreds of shires and poets, and we had to go right into Pakistan, we had to go into UK, we had to go into other countries, finding out of course the artists were dead, we had to find out their family members, we had to find out the year in which they were created. So these are massive tasks. So coming back to your question, Kalyani, why is Saregama claiming? I don't know why they are claiming. Are they right or wrong has to be tested in a court of law or by posing questions to them. And which is why copyright is linked not with the owner, but the basic copyright is linked with because the songs that you asked me about, apart from the sound recording which Saregama can claim, Saregama also will claim that I own the lyrical work and also the melody, the melody. Because they say they most often say that this was also assigned to us, although in many cases I found them not to be able to evidence it, but the claim also is that is also ours. Now those two aspects go on to life of creator plus 60 years. Sound recordings will follow the timetable given by the law. Yes. Yeah. I'm just reading Hassan's question. Performing rights. There is a huge battle going on between performing artists and recording labels. Yes. Whether the rights of master files are held by the record labels. On paper, They pay big amounts to the artist as their payment, which is exceeded by the actual amount that the distribution of the music makes. And they never get the money and don't even get the rights. So how do we move forward in a world with big international artists can't get their way? You are so right, Hassan. You are so high. It's an unfairly balanced world, and yes, the smaller artists have a long way to get, have a long path to, long and arduous path to trek to get their rights. How this eventually will pan out, I really may not be able to guide you on that right now, because I'll tell you why. Because I'm not in this matter. I do not know the details of this matter. So I may not be able to flesh out for you any definitive answer to your question. Do Kalyani also wants to know whether cover songs come under statutory license once the after 5 years. So there is a concept. There is the section 31C, if I'm not mistaken, refers to statutory licenses, and any person can deal with them. Now, one minute. So the way to go about covering the way to go about making cover songs is mentioned in the law. Section 31C says that a person who wants to make a cover has to give a notice and has to pay certain monies fixed by the copyright board. Yes. Now whether 5 years or not is mentioned is not mentioned in the law, and therefore sound recordings. But what is mentioned is you cannot make sound recordings for 5 years. You get the difference? That provided that sound recordings shall not be made until the expiration of 5 calendar years. So therefore you the 5 years from your question needs to be looked at a little differently. I don't know whether you meant the answer I'm giving you, or whether you meant I think you meant that only. You meant what is stated in the law. Do cover songs come under statutory license after 5 years? Yes. I'm sorry. I slightly misread your question and I got a little confused. No, your question is very right. Your question is that the answer to that question is yes. You can make a cover song after 5 years. Okay. Oops. Okay. Suruchi Kumar, your question is, what are the key terms and conditions you should bear in mind while drafting and entering into an agreement on podcasts? Slightly big question for today's evening, Suruchi. So let me get back to you. We'll answer this question in a little more detail for you. Yes, answer to let me see if let me give you the answers to the questions I asked you. So I said registration of a work is mandatory. Answer to that is no. Do I infringe copyrights in a sound recording when I download music from the internet for my exclusive personal use? Well, many of you said no, and that was the trick question actually. For my personal exclusive use, I think that's what misled you into believing that you can do it. Well, the answer to the question is really no. You cannot make a copy of that work. That's the simplicity answer. Whether for personal use or not really may not come into the debate. You just have to ensure that you're not making a copy of it. And if you're making a copy of it, then you have a problem. Then the next question was 5 minutes. Sharing a link to online content amounts to infringement. Very interestingly, the answer is no. So all those of you who said no are right. Sharing a link to an online content does not amount to infringement because you're not creating a duplicate work. Again, mind you, go back to section 14. Are you creating a new work? Are you creating a parallel work, a copy of the work? If the answer is no, you're not doing it. Okay, sharing of a book does not violate copyright. I answered that question to you earlier. Let me see the best method for low income artist group. in his art without disturbing the... I have not followed Sushma Bane's question when she asks, can you please guide what would be the best method for a low-income group artist to grow in his art without disturbing the copyright law, as not all dancers can afford orchestra recordings for every performances, and YouTube is our only way to go. Sushma ji, you have very little option. A little relief I can put to you is that many of these platforms, many of these right owners, now let me not say whether it's YouTube, whether it is the copyright societies or whoever, are generally very, very considerate in their fees if you can talk to them and explain to them your use. And I have seen, participated, dealt with numerous such transactions where we have requested and societies have agreed. I must also tell you, they've also not agreed, and matters have gone to major battles between your radio channels and the content owners. So that's also there. But largely, people, young artists and low-income artists, may be able to find some relief in that. Okay. Some conversation happening between Fabi to panelists. Tricky question. It depends. If I can get what Fabi is talking with the panelists, is I would say for some of them, you might download, hold, or share illegal content without knowing, which makes it illegal. Yes. To say I did not know that there was copyright in this may be a very dangerous line to take in the court of law. You have to assume. How does one protect the content of their subject in a webinar? Well, in the physical world, locks, combination locks, doors, windows are possible. On the digital world, in the multimedia world, in the world of webinars and digital content, you can't protect. The only way you can protect your work is to use the softwares available to identify a infringer. And those kind of softwares are available if you have the inclination, if you're monetizing your work, or even surely for wanting to protect your reputation, your authorship and your ownership in the work. You may, of course, use those softwares to identify. You may, for example, you may provide your work to YouTube, and YouTube would put it in its database, and then use Content ID to check new material coming in against the database that it has already with you. Kalyani also wants to know whether architectural work comes under Copyright Law or Designs Act. Well, it comes under Copyright Law because the Designs Act has a slightly different... the Designs Act is also known as the Design Copyright Act in some quarters, but architectural works squarely fit into the copyright. Can a dialogue of a film be copyrighted? Interesting question. This is always the perennial debate people have. How much is copyrightable? You know, for example, the word is from the movie Sholay, that's the dialogue that comes to me immediately. Kitne aadmi the? Now, just is the word kitne aadmi the subject to copyright protection that nobody else can use this word ever? I would be a little difficult. I would be not on that side which would say yes to this. The material is too short, too general. It makes sense in a particular situation. But otherwise, to sequester these three words to a particular owner forever, virtually in perpetuity, if life for 60 years, maybe a little travesty of the copyright law, because the fair use concept might not want to support you in this. But again, let me qualify all my answers by saying that in no matter is it in no subject, in no litigation are we dealing with only a few of the points. There would be a plethora of points we need to structure to build a sound argument. Because what if it's, what may not be protectable sometimes by the copyright law, you may find a peg to hang your coat on under the confidentiality laws, under trade secret laws, under trade secret laws, etc. So various facets your lawyers would examine for you. Okay, some of the questions which I have got on my email, so if I may ask you, if I put them for you, why was my video removed, blocked, while other similar videos stay up? Well, it is the content creator, content owner who makes a claim against a particular video. If he has not made a claim against the other videos, they will stay on. YouTube has no reason to take them down, or the platform has no reason to take them down. It's only when a specific claim has been made against a specific content, which is when either you have a content ID claim or you have a takedown notice. And generally, you won't have a takedown notice without a content ID claim. Okay. How does my content get claimed on YouTube? Well, content ID, through content ID. Now, content ID is an automatic copyright management system which YouTube has. And it exists parallel to their takedown process, but it's a more humane system that they work with. So the base of the content ID is, as I said, the data provided by people. What are the other questions I have got? If I have purchased content and before inserting it into my video, and yet I have got a copyright claim from YouTube, well, please appreciate, just because you have purchased that content hasn't given you the right, an owner's right in the purchase. So, for example, when you pay money, say for Google Movies or any of the various platforms to watch a movie, you aren't buying that movie, right? I mean, even if you're buying that movie, there is an option to buy or rent. I understand that. But when you buy that movie, you aren't buying the right to make a copy of that movie. It's like buying a book. You just buy a book and put it on your shelf. But that doesn't give you the right to make copies of that book and circulate to others. Or doesn't give you a right to tear out pages from that book, take the content and insert it in your thesis or in some other book that you're writing. So those rights which exist there continue to exist in this area also. So you can't really take that, this thing. Another very interesting question is, I recorded an event. So for example, I'm assuming he recorded an event means we went to a cricket match, let us say, and he recorded an event, or he went to a live performance of Shreya Ghoshal singing, and through his video camera, he recorded Shreya Ghoshal singing, and then he uploaded it inserted that in a video. Yet he was called, he said, I shot the movie. It is on my video. It's on my camera. It's my ownership. Sorry. You remember what I told you about performers' rights? Those rights to perform and be recorded were given by Shreya Ghoshal or whoever that may be to somebody. You did not have those rights to record. Now, because you did not have those rights to record, you could not create better rights by inserting it in a video. So you are challenged in that sense. You are in a certain difficulty if you do that. Okay. What happened? Now, what happens on YouTube when a claim is disputed? Now, generally, how YouTube works, if I may share with you very quickly, you normally have content ID issuing a claim to you. Now, you have a right to dispute that claim, and once you dispute that claim, I mean, you may dispute that claim, you may accept the claim and take down your video, or you may take out part of that video, or you may dispute it. You may dispute it on grounds of it being fair use, or then maybe you may say it's my original work. Why not? You remember we spoke about the concept of originality. So you may say I dispute it for those reasons. Once you raise a dispute, the ball goes back to the other side, to the claimant side, and he has 30 days to respond to your claim. Now, how does he respond? Either he takes down the claim, he says, okay, I accept your argument, I take down the claim. I uphold the claim. He says, no, I uphold your claim. Or he says, okay, I don't want to say anything, I just let the claim expire. So the claim can also expire. Or he can file a takedown notice. Now, once a takedown notice is issued and the issue is taken down, the subscriber gets a strike. Now, 3 such strikes and your channel is out. So you have to be very careful about getting a strike. Now, if your claim is upheld, that means if the copyright owner does not accept your submissions, you also have a right to appeal. So I would suggest you should go through the YouTube policy very clearly, and you also get rights to file a counterclaim. You can file a counter notification, as they call it. So all these rights exist. And if once your video is taken down, like after a takedown order, and then you issue a counter notification, if they do not reply in 10 days, YouTube is then mandated by its own rules to upload that video again. So I'm just looking at some more questions. Do I have a right to build and use on others' works? Of course, no. The answer is no. You have no right to use and build on others' works. But while that no is just from a very, very, very conservative caution. But you can certainly use in a fair use manner. Now, what is fair use? I would always say, leave it to your lawyers to decide. But if it is fair use and holding the hand of the fair use concept, if you can build and use a copyright work, nothing prevents you from doing that. Are content owners positively prejudiced on the digital world? I would feel no, actually. They are just simply prejudiced on the work, because there are just so many people around the world out to misuse and take advantage and monetize somebody else's ideas, that it's really like somebody like Kalyani just asked the question. How does an individual owner go around that problem always? I mean, the individual's difficulty starts in identifying a copyright owner. Where is the owner? How do I get my rights? How do I get my licenses? How do I negotiate a right price? How do I get around DRMs? Now, it's a complex world for individuals when they are trying to use digital content of somebody else. What will be the meaning of copyright? Life of the owner plus 60 years? No, not life of the owner plus 60 years for a film production house. It is life of the author. Meaning of copyright is life of the author plus 60 years. And where you do not have an author, like for example, a sound recording now doesn't have an author because they have merged into that. So the owner is now the producer. So there it is 60 years from the first publication. So there's a huge battle going on between. Oh, yes, that I have answered. Hello, keen to understand the key terms and conditions. Yes. So can you please get what be the best law? Yes. What are the laws governing the tutorial of a performing art? I've been asked by somebody as to what are the laws governing the tutorial of a performing art. Okay, let me solve this question at its genesis. There are no special different laws. The law is only one. You have section 13, you have section 14, and you have section 17. Whatever you create independently is yours. Wherever you take somebody else's, be sure it's fair use. Or if you want to definitely use something and it is not fair use, seek a license or go and buy off that work and make it your own. So these are the only options that you have. Now, if that's the laws you're asking me governing tutorials of a performing art, well, if you shoot a film containing the tutorial, or you have some printed material, you just have to classify them as a literary work, artistic work, musical work, dramatic work, or a sound recording or a film, and create a copyright around it. What is important is the content inside it. If the content inside it lends itself to copyright protection, the law will come to you. If something inside that lends to copyright infringement allegation, you will have to answer that litigation. Your defenses will be fair use or originality, etc., etc. Yes, I agree with Gaurav Chopra that see, I I am instinctively a copy left person. I'm not a copyright person instinctively. But I have seen the benefits of the copyright law. I've also seen the copyright law not working to the advantage of the common man. Eventually, I tell myself that as a voter in this country, as a person whose representative eventually signs a law, a subject matter into law, I would like the laws to be more skewed towards me. At the same time, doesn't take away the incentive of the creators to make a fair income out of their works. Now, see how skewed the system is now. Originally, when the law was made in 1957, the provisions clearly read life plus 60 years, etc., etc. Clearly read that because artists at that time were always considered to be people who were not bothered about money. I mean, I know specifically from Salil Chaudhary's wife, because we were doing some matter for them in the High Court. I was specifically told by her how Salil Da would behave with money. Somebody would just come to him and just ask for ₹1,00,000 and the cupboard would be open and money would be given away. Now, these people, after their death, left very little to the family except the work and the income coming out from the work. Now, somebody asked me earlier that are content owners prejudiced? Of course they are. I'll tell you another story without taking names. A very famous number. It's a song. It's a Hindi song of national importance because Mr. Jawaharlal Nehru had something to do with that, and in the sense. Now, the gentleman, the poet, died. His daughter wanted to know. His daughter Mitul Pradeep wanted to know. I'm sharing the name with you. Kavi Pradeep, who wrote "Ae Mere Watan Ke Logo" and donated when Pandit Nehru cried and from the ramparts of the Red Fort, he declared that all the royalty of this song will go to the War Widows Fund. And after many, many years, Mitul Pradeep, his daughter, came to me and said, can we help? Can we seek to know how much money has so far gone to the War Widows Fund? I don't want to give you the answer. It's embarrassing. And that matter literally went to the court. And I think it eventually did go to the court. So, and I don't know, it got settled also finally. There was some misunderstanding or whatever. What I'm trying to say to you is that there are many, many subtopics within this. And it's a tough ask for a content creator to keep track of his revenue stream. When in Bombay, does one go to register there? Well, you can make your copyright application directly to Calcutta, Delhi, Calcutta. What are the IP laws in terms of copyrights for classical music? Classical music where the bandishes are traditional bandishes, you may have a different take on that. Or if there is largely Indian classical music lends itself more to performers' rights rather than we always had this difficulty of being unable to create notations for Indian classical music. And which is what is very common with the Western classical music, but they're more harmony-based music. Ours being a more melodic base of music, we had difficulty in recording or creating notations for Indian classical music. Of course, with the Bhatkande School of Music and the efforts of many others, Indian music can now be noted. But notations become very important because the primary requirement of the copyright law is fixation. It has to be fixed. Now, you won't be able to fix it if you can't note it. Danya and Bhakti, I'm already at 5:15. I have many more questions, but now I'm in your hands as far as the time goes. Hello?
Yes, Mr. Kher. If you would
Yes.
like to answer a few more questions, we are fine.
Suman wants to know what are the IP laws and terms of copyrights for classical music. Owner, performer is difficult to decide. The beauty about Indian classical music is not very often you are copying a piece directly. It's a different matter whether it's Sugam Sangeet or film music, where you may be able to copy a small piece which is rendered as a Sugam Sangeet. In classical music, the difficulty arises because the creator is creating on the spot. A true classical player is, although the rag may be same, but the expression of that rag, newer expressions are being given all the time. So far, nobody's been claiming rights on expressions of classical music of a particular rag, and they are therefore in the public domain. What can become an issue certainly is that if I am performing, what I would definitely look into is whether the performer's rights are being protected, whether I can monetize my skills or monetize my art through my performing rights, through my performer's rights. And that's probably the best way for a classical musician to go. And because it's very difficult for a classical musician to say that this is my creation only, because obviously you obviously appear to be knowing about classical music, so you know what I'm saying is it's very difficult for a classical musician to claim a particular piece or a particular bandish as his own original creation, and that's where a lot of difficulty arises. Apart from this, what are the other laws governing theaters or plays? Well, there are many small laws. Sid, you of course have the censorship laws, and there are various laws. I'll send across a list to you. I'm just looking at some more. I'm a songwriter who has recently released 2 songs using digital distributors over Spotify and other streamers. I haven't read the file. When I send my work to the distributor, do they get any rights? Shikhar, good question. I am a singer. Do they get any rights? So your question is, when your work flows through a distributor, does the distributor get any rights? Yes, but those rights may be more of a commercial nature, more of a commercial relationship nature. If you have signed a contract, say for example, you could have signed an agreement for 5 years or 2 years or whatever. I don't know the fine print. So to that extent, some rights may get created in the distributor. Some rights may come to vest in that person. But if you're asking me, do any copyrights come to vest in that person? Clearly, the answer is no, unless, of course, again, via that agreement, you have given him something. Then it's a different matter. But otherwise, no. I'm sorry, Rajil, you had a good question. Can the questions be put on the screen? A little late in the day for me to answer that, but maybe next time we will consider that. Oh yeah, okay. Vandana wants to know that if a college artist makes his art with mixed photographs, newspaper articles, is there a copyright issue involved there? You would be fairly secure under the fair use provisions. You would be, because I'm assuming that I'm sorry. You're asking you're asking as a collage artist. Okay. As a collage artist, if you, yes, of course, you would have a problem. Is there a copyright issue involved? Yes, there is a copyright issue involved. because you're using photographs which don't belong to you. You're using newspaper articles, the copyrights in which don't belong to you. And although, of course, I understand that in this case, the photograph and the newspaper articles have a different objective rather than the objective with which they were originally published. But I guess you would have a problem. I guess you would. But again, we may need to examine surrounding situations. Many of the somebody wanted to know about registration. Many of these registrations can now be filed online. You probably don't even need a lawyer. It's always good to have one because issues arising from the law, which the department may get in touch with you. You may need a legal help to spot it to sort it out. My thanks once again to Dhanya, Bhakti, to NCPA, to Mrs. Rao, to HSBC, to all the participants who have borne me for the last 1.5 hours. Thank you very much. It was a pleasure to be with you all. Look forward to being with you again on some other topic. Thank you very much.